The way states consider and apply the law of other states has evolved since the second half of the 20th century. One example of a court weighing its state's interest against the interests of another state is the California Supreme Court's opinion in Bernkrant v. Fowler. Nevada resident Louis Bernkrant and others bought the Granrud Garden Apartments building in Las Vegas from John Granrud. Under a deed of trust, similar to a mortgage, Bernkrant paid Granrud $200 a month. By July of 1954, Bernkrant still owed Granrud about $24,000. Granrud wanted to buy a trailer park and verbally asked Bernkrant to refinance the building's debt and pay Granrud a substantial part of the balance owed to him. If Bernkrant did this and then made subsequent payments for the rest of Granrud's life, Granrud promised to forgive the rest of Bernkrant's debt in his will. Bernkrant agreed, refinanced much of the building's debt, and paid Granrud more than $13,000. Bernkrant continued to make monthly payments on the remaining $9,000 balance. The record was silent regarding Granrud's state of residence when this refinancing agreement was made, but Granrud was a California resident when he died in 1956. His will didn't mention canceling Bernkrant's debt, which at that point was about $6,400. In a California trial court, Bernkrant sued Dorothy Fowler, Granrud's executrix, seeking to enforce Granrud's promise. The trial court determined that Bernkrant's claim was barred by both the Nevada and California statute of frauds. Bernkrant appealed to the California Supreme Court, arguing that Granrud's promise was enforceable under Nevada law and that Nevada law should apply to this dispute.